Lord, Transgender Act is the response of the Parliament, my lord, in view of Navtej Johar, my lord, and other judgments, my lord. There are specific provisions where discrimination is prohibited and is criminalized. I'll take your lordships to the, my lord, scheme and architecture of the Transgender Act. There is no stigma. The limited question is whether right to marry can be prayed for as a social institution by way of a judicial adjudication before this honorable court. Right to marry does not include right to compel the state to create a new definition of marriage. Parliament can do. But it's not an absolute right. Now, my lord, kindly consider when your therefore, my lord, again at the cost of repetition, my appeal to your lordship is, my lord, that rather than, my lord, taking this matter any further, if your lordships are convinced that this is possibly a subject which may better, my lord, be left to the choice of the parliament, which is the law, my lord, if need be, I'll assist your lordship with that law. And the subject is such that your lordships may not be in a position to conceive of variety of situations which may arise and which will have to be taken care of. Lord, mere declaration that they have a right would be, my lord, begging the question. If they have a right, how the rights would be regulated? How variety of problems will be solved? And I'll give examples, my lord, which only parliament can take care of. Now, my lord, kindly consider, my lord. Pre-56, marriages used to take place between heterosexual persons, my lord. Conventional man, conventional woman. There was no recognition except societal acceptance. Correct, my lords? Once it gained societal acceptance, in Hindus at least, it came to be codified in 1956 by way of a Hindu Marriage Act. For other religions, by and large, it remains uncodified. Marriage between heterosexual, same religion persons. I am on the concept of marriage, the social status which it gets. Now, my lord, the moment any right which was pre-existing even without recognition by law is recognized, it is also regulated. And then there is no absolute right to marry even today between heterosexual couples. And why I say this? A man has to be 21 years and a woman has to be 18 years, meaning thereby the law prescribes when to marry. The autonomy goes. Bigamy is prohibited. So law prescribes how many times you can marry simultaneously till your wife is or husband is alive. There are prohibitions regarding degrees of prohibited relationships, meaning thereby law regulates whom not to marry. Once the law recognizes this socio-legal institution as a marriage, you just can't walk out of that institution. Law regulates even that, on what grounds you can have judicial separation and on what ground you can have divorce. So how to separate is also a legislatively regulated provision. So coming to the privacy part, even the codified law amongst heterosexuals protect the privacy of man and a woman inside the bedroom. But there are certain provisions where there is an intrusion to privacy rights also. For example, importance is a ground for divorce. That is something very, very private and personal between the two human beings. But then, if it is a case of divorce, you will have to come out and prove it. So your privacy is breached. Substance of my submission, which I will elaborate, is that once a legislative recognition is given to a particular form of union, it comes with it several regulatory provisions. And it is only the parliament, my lord, which can conceive of several situations which would arise in this relationship, which is now recognized, and can provide for its regulation. It would be impossible for the court to conceive all situations. Now, my lord, my propositions, my lord. I'll just, my lord, one of my lord, there are 10 propositions, my lord. My lord, the very heart of Special Marriage Act, and I'll show that, is a recognition of marriage between a conventional man and a conventional woman. Your lordships need not, Lord, write, because I have, Lord, in that page 3, my lord, I have, my lord, written them. Second, the request, my lord, and I will demonstrate, my lord, more effectively. The request ultimately is that you please rewrite to suit our situation, which can be done by the parliament. I am not, my lord, opposed to the situation or some regulation coming into place. By whom is the question? And that rewriting would not be possible this also, your lordships need not, my lord, good. So, my lord, your lordships exercise would be constrained, my lord, by 4 fundamental principles. One, the court will not change the character of the law. And the character, your lordship, will have to examine from the entire architecture of the act, read with all allied statutes and the history which preceded enactment of the Special Marriage Act. Second constraint would be the court cannot substitute the legislative intent which is otherwise manifest. And third, your lordships will not, my lord, read words of larger amplitude in place of words of smaller amplitude, namely, person is a word of larger amplitude in place of male and female. Next, my lord, proposition. Lord, this exercise, even if your lordships are persuaded to undertake, would necessarily have an unintended impact on the heterosexual couples, because Special Marriage Act essentially is for regulating the marriages between intra-faith heterosexual couples. Now, I'm sorry. Next proposition is, your lordships would not, my lord, undertake an exercise whereby the same statute is applicable differently to one class of persons and totally differently to another class of persons, namely heterosexuals and non-heterosexuals.
Where the same statute is applicable
to different classes of
So we
persons,
use
my lord, namely heterosexuals and non-heterosexuals.
one lens for heterosexual couples and another lens for non-heterosexual couples.
Yes, my lord. And I'm grateful, my lord. I could not put it that succinctly, my lord, but that's the respectful submission. And it would be impossible for your lordships to reconcile this classification. I'll be able to show from the scheme and structure of the Special Marriage Act. Next, my lord. Lord, we are dealing with, let us understand what we are dealing with. Lord, we say LGBTQAI plus. Correct, my lords? We know L stands for lesbians, G for gays, B for bisexuals, T for transgenders, Q for queers, I for intersex, A for asexual. Look, we have not tried to know what plus means. And my lord, this is going to be the core of the problem which your lordship would face if the judiciary were to take over the function of regulating the relationship after recognizing it as a socio-legal relationship. Lord, there are 72 shades or variations. That is why, my lord, what we write is plus. And please examine, my lord, how your lordships would, even if your lordships are persuaded to, my lord, kind of undertake an exercise of rewriting, my lord, deal with these varieties of situations. My lord, please allow me to place, my lord, that, my lord, at page. I'll just, my lord, give some examples to, my lord, annexure A, page 109.
of what, Mr. Solicitor?
My lord, of my written submissions, my lord.
Just go.
Lord, my Lord Justice Paul, my Lord, has my written submission.
Yes, yes.
There are several different shades and spectrums, my Lord. It's not that we are dealing with either lesbians and gays and transgenders. We are dealing with, my Lord, it is note 1, read submissions on the question that only legislature can deal with the subject matter. I'll just, my Lord, give some examples. I'm not going to read all 72 categories. Lord, can I, for ready reference, Lord, give the physical copy?
No.
Which page you said, Mr.
Note.
Solicitor?
Referring to
Nothing
written
of the
submission.
kind. In fact, your physical copies, please send them away back to your office.
PDF 113, my lord. I'm sorry, my lord. It was a loose ball. I forgot that I am also using a physical copy, and your lordship's continuing mandamus is being breached, my lord. Kindly pardon me, my lord. For
Threat is that they're going to be confiscated.
yes, my lord. I will be, my lord, on
There are
virtual
this
from tomorrow.
Union of
Union
India
of
submissions.
India submissions कहाँ पर है?
Let's take one, this
Volume
one.
did you say, solicitor?
Note
Volume?
1.
Note
Note
1.
Yes.
Written submissions, note 1, only the legislature can deal with the subject matter. Is that
That's
what
the
you
title, my lord.
Yes.
Uncover. Yes.
Submissions on the question.
This
Related
one.
definitions, huh? Other related
Union of India
definitions.
folder.
Opening statement.
Union of India folder.
Page.
Yes.
Note 1.
Page 113 is other related.
Got it.
Note 1. Only the legislature has the power.
Paul is leading us. That's very nice.
Yes.
The PDF number 113?
Yes, PDF 113.
Where all these definitions are given.
Yes. My lord, kindly, my lord, now visualize
DFC.
your lordships were to give recognition to LGBTQ plus, which is an unidentified class of persons, and there are at least 160 statutory provisions in different statutes. How, my lord, we will be able to reconcile with this, my lord, different spectrums and shades? Please see first, a gender. A person who does not, your lordship gets, my lord, the Chief Justice,
Yes.
your ladyship gets, my lord. A person who does not identify themselves with or experience any gender. A gender person are also called null gender, genderless, gender void, or gender neutral. Please see 3. I'm just giving, my lord, a flavor, my lord, that it's impossible to reconcile by in a judgment. My lord, even Parliament will have to undertake a humongous exercise if the Parliament, as a policy, decides to recognize the marriage. A gender that is indefinable or indomitable, people identifying with this gender refuse to be categorized in any particular gender identity. So whether they are man or woman, which provision of which law which governs either man or woman, Lord, will be a big question. Then 4, also called avious gender, this gender identified changes according to one's surroundings. This is kind of a fluid. There is nothing not specific. Then 6, this is based on the person's mood swings or fluctuations. So a person can be having, my lord, male sexuality for some time and a female sexuality for some time. And say at the time of divorce, if a lordships were to read person and they get the recognition of marriage under the Special Marriage Act, Lord, what would be their gender when we test, my lord, the grounds of divorce?
What is the source of this table,
Oh,
Mr. Solicitor?
My lord, this is, my lord, I don't think, my lord, it is. There are various sources, my lord, but essentially from
Must be taken from somewhere, some glossary or something like that.
medicine net.
Turn to the previous page. It gives it the footnote. Forces medicine. Either.
But my lord, I have checked up from 2-3 sources. This list is consistent.
Yes, yeah. You have given in your footnote
In the
45.
footnote, yes, my lord, I have given medicinenet.com.
On page 108,
Physical 100.
footnote 45 at the heading. Source, Medicine Net.
Footnote 43, my lord.
What are
45.
the others? 72
45.
others.
Then, my lords, 8. Alexigender, the person has a fluid gender identity between more than one type of gender, although they cannot name the genders they feel fluid in. Then the gender identity stands apart from existing social gender constructs. It means having a strong specific gender identity that is neither male nor female. My lord, transgender, my lord, is different. Transgender, my lord, is conventionally, as we know, is different. Now defined to mean everything, my lord. But transgender means, my lord, the person who has sexual genitals other than what, my lord, he is supposed to be born with. My lord, then amaragender, having a gender identity that changes depending on the person one is emotionally attached to. if a person is emotionally attached to a man, then he has a male sexuality. If woman, then he has a feminine sexuality. Then embonic. The person identifies themselves as both man and woman and yet does not belong to either. Therefore, I repeatedly say this is an unidentifiable class we are dealing with. Then amica gender, a gender fluid identity where a person changes their gender depending on the friends they have. It's also called, my lord, by some as pure gender, my lord. My lord, 17, my lord. Anogender. The gender identity fades in and out in intensity, but always comes back to the same gender feeling. So at particular act, he has one gender identity, then it changes, it comes back. These are not facts I'm giving. I'm without having any value judgment. The only limited purpose of showing is that would it be prudent or possible for the court to lay down, my lord, regulations, even if your lordships are persuaded to confer them with the socio-legal status of marriage. Because then regulating it would be impossible because there would be 101 contingencies, which my lord, with best of the assistance on our side, your lordships, my lord, cannot conceive of. Then, my lord, kindly turn the page. My lord, 27, exigender. A gender identity that is between the two extremes of agender and any other type of gender. Both the genders are experienced one at a time without any overlapping. The two genders are described as on the opposite ends of an axis. Then bigender, having two gender identities at the same or different times. Then 30, blur gender, also called gender fuss. Blur gender means having more than one gender identities that blur into each other so that no particular type of gender identity is clear, etc., my lord, etc. I'm not giving examples, my lord. Now, my lord, your lordships are necessarily dealing with an unidentifiable class. Now, please come to, my lord, page 16 of my written submissions. Lord, would it be prudent or legally permissible, my lord, to deal with this subject, my lord, on the judicial side? Your lordships are not examining a prohibition against marriage. My lord, kindly bear this distinction is mine. There is no prohibition amongst LGBTQ plus community to marry. Your lordships are not examining the validity. Your lordships are being requested to confer a legal status of marriage which all religion considers to be an institution. I'm not on the morality of it, though that would be a valid consideration. Lord, page 4 to 15, I have given, my lord, what is the institution of marriage in the Indian context? In case of Hindus, what the Hindu scriptures say. In case of Muslims, what Holy Quran says. In case of Christians, what Holy Bible says. It's a social institution conferred with the legal status. And all these social institutions are predating the statutes and have accepted marriage as an institution only between heterosexual couples. And again, my lord, we are not sitting in judgment over that decision. That's what the society has accepted. since millions of years.
Solicitor, where are you referring to on this aspect?
My lord, page 4 to 15,
Of
my submissions, my lord. Page 6 to 15, I'm sorry.
Actually,
Even, my lords,
your formulation, you see, is best brought out in page 11,
yes, my lord.
para 44.
Yes, my lord.
Those 4 points.
My lord,
what I-
may I just read, my lord, for your, my lord, so that I make myself more clear. The world religions have shaped the history of marriage and family and continue to form the basis of marriage as an essentially religious concept. While it is correct that there is significant divergence between different faiths and their practices in relation to marriage, what must not be lost sight of is that there is more convergence than conflict in teachings of marriage and family. All six major world religions overlap on the following attributes of marriage as identity. Then I have given the source. First, each of these religious traditions confirms marriage as a vital and valuable institution and practice that lies at the heart of the family and at the foundation of broader society. Second, each tradition recognizes that marriage has inherent goods that lie beyond the preferences of the couple. One fundamental good of marriage emphasized by Judaism, Christianity, Hinduism, and Confucianism is that the husband and wife complete each other. Indeed, they are transformed through marriage into a new person, a new one, fresh reality. Another fundamental good of marriage is the procreation and nature of children. Lord, this is not an archaic concept. Special Marriage Act uses the word procreation. Children are sacred gifts to a married couple who carry forth not only the family name, lineage, and property, but also the community's religion, culture, and language. All these religions thus see a close relation between marriage and children, just as they saw a close relation, although not an identity, between marriage and sexual expression. And all these religions teach that stable marriages and families are essential to the well being of children. This is what my Lord Kara says in the adoption. 2 years of stable relationship as husband and wife. Third, each tradition regards marriage as a special form of sacrament, promise, oath, or contract over any generic relationship, economic or social. It has a special, unique status, my lord. For Hindus, it is a sacrament. For Muslims, it's a sacred contract, but nonetheless a sacred contract. And across the faith, what is recognized as a marriage is between heterosexual couple. Fourth, each tradition eventually came to insist that marriage dependent in its essence on the mutual consent of the man and the woman. Even if the man and women are represented by parents or guardians during the contract negotiations, their own consent is essential to the validity of their marriage. Jewish, Hindu, Confucian, and Muslim writers came to this insight early in the development of marriage. The Christian tradition reached this insight canonically only in the 12th century, and Buddhism more recently still. Fifth, marriage is a concept that is deeply embedded as a union between two opposite sexes ordained by the religious text and practices specifically for the furtherance of society and the orderly influence between persons inhabiting the society and following specific religions. Now, your lordships have a variety of shades to be dealt with, variety of problems which are to be encountered, variety of religions and their personal laws, my lord, intermingling, and your lordships have an option on, in my respectful submission, possibly the only constitutionally permissible option to require the parliament or to wait for the parliament to do that. My lord, please now come to page 16. My lord, I am citing some judgments. I will not read all, but these are, my lord, some very illuminating judgments, my lord. At page 17. My lord, right
1-7.
1-7. It starts at 1-6. The title is Democratic Right of People to Regulate Themselves.
You
But
said
we as a society has a right to regulate ourselves.
176.
My lord, PDF 25. 21, my lord. PDF is 21, my lords. We as a society, my lord, govern who will be the components of that society, my lord, and that governance comes in, my lord, the elected representatives whom we decide, my lord, to elect. Now, please come, my lord, this Reynolds Rajmani judgment. I'll read only the highlighted part, my lord, so that I don't invest your lordships more time. It cannot be denied that society is generally interested in maintaining the marriage bond and preserving the matrimonial state with a view to protecting societal stability, the family home, and the proper growth and happiness of children of the marriage. I'll skip the rest, underline portion. But although the grounds for divorce have been liberalized, they nevertheless continue to form an exception to the general principle favoring the continuation of the marital tie. In our opinion, when a legislative provision specifies the grounds on which divorce may be granted, they constitute the only conditions on which the court has jurisdiction to grant divorce. If grounds need to be added to those already specifically set forth in the legislation, that is the business of the legislature and not of the courts. Lord, please, Lord, see these, my Lord, in light of what I'm going to show. The structure of the Special Marriage Act would be, if it is redrafted the way petitioners have prayed for. Even the prayers are, my Lord, absolutely vague. I'll be able to demonstrate that. But first, my Lord, law on the point. 5. When therefore Section 10 of the Indian Divorce Act specifically sets forth the grounds on which a marriage may be dissolved, additional grounds cannot be included by the judicial construction of some other section unless that section plainly intends so at the foot. However, whether a provision for divorce by mutual consent should be included in the Indian Divorce Act is a matter of legislative policy. The courts cannot extend or enlarge legislative policy by adding a provision to the statute which was never enacted there. Therefore, I started by saying that marriage is a socio-legal institution. Its recognition is a matter of legislative policy. Then, my lord, Keshavanand Bharti, my lord, kindly allow me to read, my lord. This would guide, my lord, us throughout, my lord, the hearing of this case. How we construe the constitution in the context of the marriage being given the recognition, my lord. Underline portion. It cannot be denied that provisions of the constitution of other countries are designed for the political, social, and economic outlook of the people of those countries for whom they have been framed. The seed of the constitution is sown in a particular soil, and it is the nature and the quality of the soil and the climatic conditions prevalent there which will ensure its growth and determine the benefits which it confers on its people. We cannot plant the same seed in a different climate and in a different soil and expect the same growth and the same benefit therefrom. Law varies according to the requirements of time and place. Justice thus becomes a relative concept varying from society to society according to the social milieu and economic conditions prevailing therein. The problems which confront those courts in the background of the state of the society, the social and economic setup, the requirements of people with a totally different ethics, philosophy, temperament, and outlook, differentiate them from the problems and outlook which confront the courts in this country. It is not a case of shutting out light where they could profitably enlighten and benefit us. The concern is rather to safeguard against the possibility of being blinded by it. Lord, this takes us to, my Lord, the theory that ultimately societal acceptance is one of the considerations for recognition of any union. And that can be tested only in the legislature. And, my Lord, there is a beautiful passage I'll read, my Lord, from the American Supreme Court, which says that any recognition by the court does more harm to LGBTQ plus community than help them. Because then you are forcing something which should have come from within. That's the logic, my lord, of the Honorable Supreme Court. Now, my lord, A.K. Roy, my lord, 5-judge bench. I'll read, my lord, the highlighted part. But we cannot transplant in the Indian context and conditions principles which took birth in other soils without a careful examination of their relevance to the interpretation of our constitution. No two constitutions are alike, for it is not mere words that make a constitution. It is the history of the people which lends color and meaning to its constitution. Lord, we cannot forget the historical background and the anthropological background, my lord, which eventually resulted into creation of an institution called marriage across faiths, across religion. Now, my lord, your lordships have seen, but my lord, Justice Cardozo, my lord, a little hard-hitting, my lord, word, but my lord, it really, my lord, I would wish, my lord, to place it. When they say that all we want is a recognition, all we want is the confirmation of our right. The judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is not a knight errant roaming at will in pursuit of his own ideal
process.
of beauty. I'm sorry.
It's the nature of the judicial process.
Process.
you're quoting from.
That's correct. That's correct, my lord. But, my lord, only few words I wanted to highlight, my lords. Not the first part, which is slightly, my lord, a little more harsher, my lord. But thereafter, he is to draw his inspiration from the consecrated principles, and this is important. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. That's what, my lord, I am driving at. The class with which, my lord, your lordships are dealing is an unidentifiable class. They have their class-specific problems. It would be completely, my lord, a vague declaration, if at all it is to be made, without, my lord, conceiving the problems they would be creating, my lord. The mere declaration would continue. He is to exercise a discretion informed by tradition, methodized by analogy, disciplined by system, and subordinate to the primordial necessity of order in the social life.
Primordial.
I'm sorry, primordial.
I think our own Justice Patanjali Shastri has put it all in that one short paragraph in V.G. Rao. Everything that is on reasonableness and
Yes,
what is the
yes.
role of the court.
Yes. My lord, kindly come to, my lord, para 74, para 73, 74, and 75. This would be relevant, my lord, for my purpose, because I'm going to, my lord, rely upon Obergefell, Windsor, and, my lord, their dissent. A beautiful dissent, because for us, both, my lord, majority, minority, both are having persuasive value. It was a thin majority of 5 versus 4. But numerically, yes, majority, my lord. Dissent is a dissent, but, my lord, which would really assist your lordships. Now, your lordships may kindly see the landmark dissent of Justice Oliver Holmes in Lochner versus New York, which criticized the majority of the court for becoming a super legislature by inventing a liberty of contract theory, thereby enforcing its particular laissez-faire economic philosophy, is still remembered as a remarkable piece of judicial foresight. My lord, then I have cited, my lord, this judgment with a reason. My lord, please allow me to cite Daybright lighting. I'll just read, my lord, the highlighted part.
Yes.
Our recent decisions make plain that we do not sit as a super legislature to weigh the wisdom of legislation, nor to decide whether the policy which it expresses offends the public welfare. Lord, 75, and before I, my lord, read that, my lord, I would like to, my lord, just paraphrase it. Specifically, the dissent of Justice Holmes came to be fully accepted in Ferguson versus Krupa. and continues to be the law of America till date. Interestingly, the dissent in both in the American Supreme Court in Obergefell versus Hodge and United States versus Windsor blame the majority for committing the same mistake it did in Lochner suit. I'll read, my lord, and thereafter, what happened after, my lord, this Obergefell judgment in Dobbs. This is doubted. Now, your lordships may, my lord, kindly directly come to, my lord. My lord, the rest of the judgments are same, that your lordships would not, my lord, as a prudence and as a policy, substitute the wisdom of the legislature. But, my lord, kindly come to page 23, that is, my lord, 27 PDF. Only the highlighted part. Your lordship gets, my lord Justice Narsip. Lord, page 23, PDF 27, my lord Justice Butt and Justice Call.
Yes.
Read the highlighted part. The power of the court to legislate is strictly limited. Judges ought to remember that their office is just decree and not just dere to interpret law and not to make law or give law. Chief Justice Chandrachud, my lord, this can be, my lord, said now, my lord, that's my request. Chief Justice Chandrachud can say this, my lord, in the present judgment, my lord, on the lighter side, my lord. Chief Justice Chandrachud, speaking for a constitution bench in Gurbakh Singh, CBI versus State of Punjab, has clearly pointed out the limited powers of the court to make laws in construing the provisions of the statutes. The learned Chief Justice has observed the true question is whether by a process of construction, the amplitude of judicial discretion which is given to the High Court and the Court of Session to impose such conditions as they may think fit while granting anticipatory bail should be cut down by reading into the statute conditions which are not to be found therein. Our answer clearly and emphatically is in the negative. Nothing more can be read into the statute. Then, my lord, again the learned Chief Justice warned, judges have to decide cases as they come before them, mindful of the need to keep passions and prejudices out of their decisions. And it will be strange if, by employing judicial artifices and techniques, we cut down the discretion so wisely conferred upon the courts by devising a formula which will confine the power to grant anticipatory bail within a straitjacket. Therefore, even if we were to frame a code for granting of anticipatory bail, which really is the business of the legislature, it can at best furnish broad guidelines and cannot compel blind adherence. The court, by its very nature, are most ill-suited to undertake the task of legislating. There is no machinery for the court to ascertain the conditions of the people and their requirements and to make laws that would be most appropriate. Further, two judges may think that a particular law would be desirable to meet the requirements, whereas another two judges may most profoundly differ from the conclusions arrived at by two judges. Conscious of these handicaps, the law requires that even an amendment of the Supreme Court rules, which govern the procedure to be adopted by it for regulating its work, can only be effected by the whole court sitting and deciding. Lord, the court puts a word of caution that though, my lord, one of the finest, my lord, intellectual brains of the country would be deciding this, but Lord, that would not reflect the will of the people. Then, your lordships, my lord, kindly come to page, my lord, I'll just read, my lord, at page 24, that is 29 foot. My lord, it's a constitution bench judgment and only the highlighted part at page 29, my lord. 25, my lord, PDF 29. the court also needs to be mindful that a legislation does not become unconstitutional merely because there is another view or because another method may be considered to be as good or even more effective, like any issue of social or economic policy. It is well settled that the courts do not substitute their views on what the policy is. But my respectful submission is policy throughout all legislations, including Special Marriage Act and Hindu Marriage Act, is recognition of marriage as a socio-legal institution between heterosexual couples. That policy can be reviewed, reconsidered, and redecided by the Parliament, having, my lord, after having wider consultations and, my lord, after gathering all the facts, gathering all possible scenarios which need, my lord, to be regulated. Now, your lordships, my lord, come to page 26, my lord. 20, that is 30, PDF 30. First unnumbered paragraph, my lords. Does my Lord Justice Bhatt and Justice Kaul as well?
Dobbs.
Yes. May I read, my Lord, with my Lord's permission?
Yes.
Your Lordship gets one. My Lord, the Chief Justice gets one.
Page 30, right?
Yes, PDF 30, my Lord.
Yeah.
First unnumbered paragraph.
Yes.
This understanding has also come to be judicially accepted even in the United States, which had earlier permitted same-sex marriage by judicial decision. The United States Supreme Court in Dobbs versus Jackson Women's Health Organization has held that fundamental rights must be objectively, deeply rooted in the nation's history and tradition. Granted recognition to same-sex marriage. Further, the majority led by Justice Alito in Dobbs' case was emphatic in what it referred to as usurpation of power by the court and held that the issue be returned to the elected representatives. After doubting Obergefell, which permitted same-sex marriage. And in Dobbs, they say, we send it back to the elected representative, namely the Senate. Lord, please read, my Lord, Justice Alito. Roe, my Lord, that is Roe versus Wade, my Lord, your Lordships are aware. Roe was in collision course with the Constitution from the day it was decided. Caisse perpetuated its errors, and those errors do not concern some arcane corner of law of little importance to the American people. Rather, wielding nothing but raw judicial power, the court usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. Caisse described itself as calling both sides of the national controversy to resolve their debate, but in doing so, Caisse necessarily declared a winning side. Then again, my Lord highlighted the underlined part. Put aside the second and third factors, which were based on the court's flawed account of history, and what remains are precisely the sort of considerations that legislative bodies often take into account when they draw lines that accommodate competing interests. The scheme Roe produced looked like legislation, and the court provided the sort of explanation that might be expected from a legislative body. Lord, reasons which the petitioners urge are the reasons which can be given, accepted, rejected by the Parliament. Our decision returns the issue of abortion to those legislative bodies, and it allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office. Of a constitutional right to obtain an abortion. Indeed, this case, 26 states expressly ask us to overrule Roe and